Okay, I think it's a good time to get started.
Okay, great. Thanks, Allie. Welcome, everyone, to the fourth installment of the WRJ Women Act webinar series. My name is Jane Taves. I'm the incoming WRJ Vice President of Advocacy and Marketing and Communications. This is a role that I will begin in just over 1 month. I have been finding this series of advocacy webinars extremely valuable and well done. And I'd like to introduce you to the woman who's responsible for that excellence, Allie Mallinger, who is our WRJ Advocacy and Communications Associate.
Thank you so much, Jane. So I'll be just talking about the series a little bit. So back in January, we announced the WRJ Advocacy Plan. It identified 6 high-priority social justice issues that we will be focused on to shape our advocacy work. So those issues include pay equity, violence against women, women's health and reproductive rights, economic justice, Israel, and immigration reform. So today we'll be talking about specifically reproductive rights, but throughout this series we've just been able to discuss many aspects of these issues, including current Supreme Court cases, women's health programming around Breast Cancer Awareness Month, and pending legislation revolving around immigration reform.
And now the details of today's session. 3 days ago, we got to celebrate the 45th anniversary of the groundbreaking Roe v. Wade Supreme Court decision. This case granted the right of privacy under the 14th Amendment to extend to a woman's right to an abortion. Nevertheless, this case has been continuously challenged since its ruling, and multiple state regulations make access to abortion today nearly impossible. This session will discuss what this case granted and how those rights are being challenged throughout the country. We're very pleased to have 2 expert speakers for today's webinar. First, we will hear from Rachel Easter. Rachel serves as counsel for the National Women's Law Center. The center has worked for more than 40 years to protect and promote equality and opportunity for women and families, and to attempt to champion policies and laws that help women and girls achieve their potential at every stage of their lives. Rachel has a particular focus on reproductive rights, including access to birth control and abortion. And then next we will hear from Rabbi Jennifer Jake. Rabbi Jake serves as the senior rabbi at Temple Israel of Northern Westchester, New York. She's an insightful leader and a gifted educator who interprets the complexity of contemporary American life through the prism of our Jewish history and its traditions. Rabbi Jake is co-chair of Reformed Jewish Voices of New York State and serves on both the Union for Reformed Judaism's Commission on Social Action and the Central Conference of American Rabbis Committee on Justice, Peace, and Civil Liberties. She's also active in interfaith work in the community. And with that, I will turn you over to Rachel Easter.
Thank you so much. I really appreciate being invited to speak about this important issue today, particularly given that just a few days ago, as you mentioned, we celebrated the 45th anniversary of the Supreme Court's decision in Roe v. Wade. So what I want to do today is to walk us through sort of what the Supreme Court has done over those 45 years, because what Roe looks like then and what Roe looks like in 2018 is a little different. So I'm going to walk us through 3 major cases: Roe v. Wade, Planned Parenthood versus Casey, and Whole Woman's Health versus Hellerstedt, which was as recent as 2016. And then from there, talk a little bit about, given current Supreme Court ruling on abortion, what is it that we see states and the Trump administration and Congress doing to undermine this right? So I will go ahead and jump in on Roe, if I can get the next slide. So we know that Roe v. Wade is the super controversial thing in 2018. So folks are often surprised to learn that it wasn't that controversial when it happened. In 1973, it was a 7-2 decision. And what the court said in Roe v. Wade was that the 14th Amendment's protection of the constitutional right to privacy includes a right for a woman to decide whether to obtain an abortion. It wasn't the first time they'd recognized this right to privacy. They'd previously recognized it in cases about the use of contraception, but it was the first time that they explicitly ruled on the issue of abortion. So what the court finds here is that privacy here is a little different. You have this right to privacy, you have a right to decide whether to have an abortion, but the government also has some rights that can weigh against that, and that is that your right to terminate a pregnancy is not absolute or unqualified. They can restrict that right in order to protect the woman's health or to protect the potential for human life. But still, the Roe v. Wade decision itself was really expansive. In the years following Roe v. Wade, we saw all sorts of abortion restrictions struck down under sort of this ruling. Could they ban a particular abortion method? The court said no. Could they require parental consent? No. Could they require a 24-hour mandatory delay between when you first see a doctor and get an abortion? No. So what happens, because for those of you who follow this stuff, you know that we end up seeing these laws again in the 2000s. Well, in 1992, the court decides the case Planned Parenthood versus Casey. Next slide, please. Okay, so in Planned Parenthood v. Casey, the court did reaffirm Roe v. Wade. They said, yes, you still have this constitutional right to decide whether to have abortion. But they do narrow that right somewhat. They say the government has more of an interest in protecting women's health and potential life than we really said in Roe v. Wade. And they create this new weird test for deciding whether a restriction on abortion is constitutional or not. This new test that doesn't apply to any of our other constitutional rights, and that's called the undue burden standard. And specifically, they say that an abortion restriction cannot place a substantial obstacle in a woman's path to getting an abortion, which, as a lawyer and as non-lawyers, I think we can all agree that's pretty confusing. What constitutes a substantial obstacle? Because that's vague, that opens the door for state and federal lawmakers to try and make an end run around the Constitution and place all of these restrictions on a woman's constitutional right to decide whether to have an abortion. And so what ends up happening is in the years following Planned Parenthood versus Casey, we see a huge increase in the number of restrictions, particularly even in just the years from 2011 to 2016, when Whole Woman's Health v. Hellerstedt was decided, we saw more than 300 restrictions on abortion pass throughout the state. And these restrictions did everything they could to make it difficult, if not impossible, for women to get an abortion, including shaming women, sometimes requiring providers, abortion providers, to give women false information, forcing women into transvaginal ultrasounds, and then making them view the ultrasound, mandatory delays, and then maybe most famously, we saw in Texas, where they tried to pass these horrendous restrictions. They passed them over the heroic filibuster of Wendy Davis, these restrictions that would have said that abortion clinics had to be a certain size, their closets had to be a certain size, their parking needs to have a certain number of parking spaces, all these ridiculous things that don't actually have to do with the procedure. And if that law had been able to go into effect, it would have closed more than 3/4 of the clinics throughout Texas. So that's what leads us to the Supreme Court case of Whole Woman's Health v. Hellerstedt that was decided in June 2016. Next slide, please. And so Whole Woman's Health v. Hellerstedt, there should be one more bullet on there, if you don't mind hitting that. Thank you. Whole Woman's Health v. Hellerstedt ends up being this phenomenal decision. And what the court does is they really strongly say, yes, this is a woman's constitutional right. And you can't restrict a constitutional right so easily. And you can't claim to be protecting women's health without backing it up with any evidence. And what they really said is the word undo means this is a balancing test. So if you're claiming that this restriction helps women, you still have to weigh any of that help or that benefit against the burden that it imposes. and weigh the two, and if the burden outweighs it, it's unconstitutional. But they said in Texas, there's no evidence this actually helps women, so there's nothing you're weighing against this huge burden, clearly unconstitutional. So really, the court didn't create a new test in Whole Woman's Health v. Hellerstedt. They just clarified for us what it means. Excuse me. And so following Whole Woman's Health v. Hellerstedt, this is a huge victory. We have seen across the country that fierce advocates are going into courts and challenging all sorts of abortion restrictions, the kind we saw in Texas, the kind we saw in that huge wave in 2011 to 2016, as well as going back to abortion restrictions that have been on the books for decades to challenge them with this new standard. And we do see them being struck down in many courts. But unfortunately, this is abortion, and it's, there are folks who are opposed to a woman's right to decide to obtain an abortion no matter what. So, and we saw the horrible election of, late 2016, and we find that lawmakers are continuing to find ways to attack a woman's ability to access abortion and really try to undermine this constitutional right. So what do those attacks look like in a post-Whole Woman's Health world? Next slide. Yeah, great, thank you. So I think that there are a couple themes we really see to the way they're trying to go after abortion access. One is to really make it impossible for women to afford to get an abortion. And what's really harmful about these types of restrictions and making it harder for a woman to afford an abortion is that it's creating this dual system where if you have money, you have access, and if you don't have money, you don't have access. So we know that one of these restrictions, the Hyde Amendment, has been in place since 1977. It has denied health coverage of abortion to individuals enrolled in Medicaid and has only very narrow exceptions for rape or incest or if the woman's life is in danger. And as I said, this is a policy founded on the idea that individuals struggling to make ends meet should and will have different healthcare options than the rest of the country. And just, a refresher for most folks, Medicaid, the women who are impacted by this, those enrolled in Medicaid, it's a critical source of health coverage for low-income individuals and their families. 46% of women of reproductive age enrolled in Medicaid live below the poverty line. That means they make less than $12,000 per year. And so the Hyde Amendment, as you can imagine, makes it impossible for many of these individuals to access abortion without coverage. And then beyond the Hyde Amendment, we see this trend of trying to expand insurance coverage restrictions. So this trend really started during the passage of the Affordable Care Act in 2010, when anti-abortion politicians fought to include restrictions on access to health coverage for abortion. Following the inclusion of these restrictions, states can now ban private insurance companies from covering abortion. So currently 26 states prohibit insurance plans that are sold on the exchange or the marketplace from covering abortion, and 11 of those go even farther and ban insurance coverage in all plans in the state. And not to be outdone, the 115th Congress has tried to make things even worse. Every single attempt we saw to repeal the ACA included additional abortion coverage restrictions. Excuse me. All of which had the ultimate goal of eliminating insurance coverage altogether, which means that women will be forced to pay out of pocket for this procedure. And we know that the median price of an abortion can range from $450 for a first trimester abortion to $1,750 for an abortion at 20 weeks or beyond. And we know that out-of-pocket costs for women can be as high as $3,700. As you can imagine, for many women, this puts them in an untenable position of trying to choose between groceries and textbooks or the health care they need, or being in a situation where an abortion gets more expensive with every week of pregnancy, and so they're constantly trying to save, but every week have to save more money, and it becomes this horrible cycle where they're just never able to save enough and are priced out of getting an abortion altogether. And we do know that the majority of women who have abortions are already struggling to make ends meet. And research shows that restrictions like the Hyde Amendment force 1 in 4 poor women to carry an unwanted pregnancy to term. And unfortunately, these types of restrictions are just not something that the Supreme Court has said go so far as to be unconstitutional. So that's one of the really big categories that we see as their way of making it more difficult. And again, I just can't stress enough how much this is a method of really targeting the women in the country who have the least money. It's really targeting poor women and saying it's okay if they have different health care than the rest of us. So then on the next slide, the other way that we really see targeting abortion coverage is allowing religious beliefs to dictate patient care. We've seen that that's something this administration is a really big fan of, is creating all of these religious refusal laws, which say that your doctor, your nurse, your hospital can refuse to provide you with an abortion, including in some situations when you might be miscarrying, but the Catholic directives say that miscarriage management constitutes an abortion. And not only can they refuse to provide you an abortion when you go to the ER in that situation or as a rape survivor, but in some situations, the administration's trying to make it possible that a doctor or a nurse or even a receptionist could deny you that and not even tell you that they have that they've denied care. So a doctor might be allowed to not even say, by the way, normally if you're miscarrying in this situation, other doctors would do this procedure, but I think that's an abortion, and so I'm not willing to do it. So as someone who doesn't know about healthcare, you could just never know that your ordeal could be over much sooner. This can result in infertility, infection, and even in some situations, death if you don't get proper miscarriage management. And I will just quickly say, because I know I've taken up a bunch of my time, that we actually saw just late last week the Trump administration really doubling down on their commitment of allowing religious beliefs to dictate patient care by starting a new division in the Department of Health and Human Services that is dedicated just to doing this and issuing a new regulation that would make it easier for folks to do it. And not only are these really horrifying rules, but they also have a little bit of a First Amendment problem because they have this assumption that faith is anti-abortion, and they are protecting one version of faith and ignoring faith and morality that says that women deserve access to this critical care. So I know I rushed through that, but I will stop for now, and at the end, let me know if you have any questions. Thank you so much.
Wonderful.
Thank you so much. Oh.
And so we'll transition from there to our next speaker, Rabbi Jennifer Jakes.
All right. Thank you so much for inviting me to speak on this issue. As I told Allison, I'm not an expert on this topic, but I'm speaking from my own experiences. So I thought I would start with the next slide, telling you a little bit about my background. I happen to be a second career rabbi, and my first career was in politics in Washington State. That's a picture of the dome, the Capitol Dome in Washington. And I worked in the state Senate for the Democratic caucus. And then I moved from that position to work as a legislative liaison for a public university. And so I got to see the legislative process from both ends, which put me in a good position for the advocacy work that I do now as a congregational rabbi. Next slide, please. So much of my work in advocacy in New York has been through an organization called Reform Jewish Voice of New York State. And it takes its name from this passage from the book of Isaiah, which talks about crying aloud, don't hold back, raise your voice like a shofar. Reform Judaism has a long history of engaging in work in social justice, and Reform Jewish Voice, from its establishment about 15 years ago, does this on the state level. Next slide, please. So Reform Jewish Voice takes positions on different issues that are adopted by the Union for Reform Judaism. We also work with other organizations in New York. When it comes to reproductive rights, we work with NARAL New York, with Planned Parenthood, and we teach advocacy and also engage in advocacy in Albany. Not just for adults, but also for teens. We want to get them involved in this important work as well. Next slide, please. So it is really important to have a progressive religious voice at the state level. What you're seeing is a picture of the Capitol building in Albany. And the reason it's important to have to hear from progressive religious voices is because most of the time the lawmakers in Albany are hearing, when they hear a religious voice, they're not hearing a progressive religious voice. So it's especially important when it comes to issues that you might say have moral overtones, issues such as marriage equality or LGBT rights, and of course, reproductive rights. It's so important for our voice to be heard too. If you could show the next slide, please. And this sign, I think, this photograph says it all. The anti-legalized abortion movement really seeks to claim the high moral ground. Here in this photograph, they're claiming to speak for God. And so it's very important for us to have our own, I guess, point of view coming from a faith perspective reflected as well. So let's take a look with the next slide at the position of the reform movement when it comes to legalized abortion. So overall, we embrace the idea that life is sacred, but sometimes it's necessary to have an abortion. And even though this is a modern position, it's really grounded in an old text. There's a text in our Torah, from the book of Exodus, that basically describes a scenario in which if a person causes a miscarriage in a woman, he's fined, but clearly, which means that the fetus had some value, but the value is not, he's not considered a murderer for causing a miscarriage. So the fetus, the life of the fetus doesn't have the same value as a human life, according to this old text from the Torah. And this idea about the relative value of life is affirmed later by our early rabbis. And they actually describe a case in which if a woman is having difficulty giving birth, that until the fetus, until its head and shoulders emerge from the mother, the life of the mother takes precedence over the life of the fetus. So that position, it has been affirmed, in the rabbinic tradition as well. And I do apologize for my grammatical error in the last sentence too. I noticed it as I was going over that this morning. This position, it's important to note, is different from the religious positions of some other faith positions or faith traditions. The Catholic Church, for example, teaches that life begins at conception. Certain fundamentalist Protestants take that view too. So in Judaism, our position is much more nuanced, but clearly we don't say that the value of the life that begins at conception has the same value as the life of the mother. If you take a look at the next slide, the reform movement has a long, long history of supporting legal abortions. What I mean by reform movement is, these are positions that were adopted by the Central Conference of American Rabbis, which is my rabbinical organization, and also the Union for Reform Judaism. Several times, these bodies have taken the position that this decision about terminating a pregnancy is a decision that should be up to the woman to make, and that we oppose any attempts to erode that fundamental right. Now, if we turn to more of the local level, with the next slide, I want to tell you a little bit about what's happening in New York. So New York was one of the first states to legalize abortion in 1970. So this is before the Roe versus Wade decision. And at the time that New York adopted legalized abortion, it was their policy was pretty progressive. But the problem is now, so many years later, it is not progressive anymore. It's outdated. And if you take a look at the next slide, I'll show you some of the ways in which the law is outdated. The basic problem is that the New York law is not in line with Roe versus Wade. This means that the law on the books in New York actually criminalizes late-term abortion unless the physician knows for certain that the mother will die if the pregnancy continues. And that's a standard that some physicians, I think, would be hesitant to make. It says nothing about what happens if it's discovered that the fetus has some kind of condition that would make life impossible. That is really not addressed in the New York state law. And also the law doesn't reflect basically the major progress that we've made since 1970 in how abortion care is now provided. When it was first passed, abortion care was usually surgical, and now that's not the only option. And most abortions, especially in the early stage of pregnancy, don't have to be surgical abortions. So that's not addressed by the New York law, too. But if we turn to the next slide, if Roe versus Wade is the law of the land, why should we worry about what's on the books in New York? Because we know that can change. If we rely on the federal government to protect these rights and the decisions of the Supreme Court, then that right can be eroded. And I think Rachel did a good job showing how people are attempting to erode the rights that are protected under Roe versus Wade. If Roe versus Wade, is overturned, New York reverts to the law on the books, and that's not something that we think would be an ideal situation by any means. If we take a look at the next slide, the Reproductive Health Act is what we have supported in Reform Jewish Voice for several years. It's the vehicle by which we're trying to update the New York state law. It's basically would bring New York state law consistent with the protections guaranteed by Roe versus Wade. Also, very interesting that right now the New York abortion laws concerning abortion are in the penal code, the criminal code of New York State. The Reproductive Health Act would move those laws over so that into the health laws, treating it as a health issue and not a criminal issue. The Reproductive Health Act has been introduced for many years now. The Assembly passes it every year in some form or another, and it dies in the state Senate. When most of the time, in the past several years when I've gone up to advocate for this act, the arguments that are brought forth to oppose it are really the most extreme arguments. It seems like people have an idea, that what we're talking about is, late term and partial birth abortions, and they bring up the most extreme cases and don't really want to move forward in passing it, which is a shame because I think we have a supportive governor in office now too. So, but we have not been able to get it past the state Senate. If we turn to the next slide, I just wanted to give you a glimpse into what I say when I go and advocate on behalf of the Reproductive Health Act. My first argument comes from my position as a rabbi. I have been in the position of counseling members of my congregation or their loved ones who face a difficult choice about terminating a pregnancy. And this is a choice that they bring a lot of care to. It's not a choice that they take lightly, and it's an agonizing, heart-wrenching choice. And so my first argument is that just like Roe versus Wade was originally about privacy, this decision should still be a fundamentally private decision, one that women make in consultation with their family, with their physicians, and with their clergy, if they have such a clergy member in their lives. If we look at the next slide, the second reason that I argue for the Reproductive Health Act is it's a matter, if we turn to the next slide, we get to, yes, that this is fundamentally about the separation of church and state. And Rachel touched on this a little bit earlier, that we should work for a society in which one religious viewpoint about when life begins or what the value of a fetus's life is, one religious viewpoint shouldn't be the one that's reflected in the law. The Jewish viewpoint is different, has a different nuance than that of the Catholic Church. And and our society, if we're going to be a pluralistic society, should have room for those differences in religious opinion and expression. So if we turn to the next slide, I think this is my last slide. The things that you can do to get more involved in this issue, if you're so moved, the first thing is to sign up for action alerts. The Religious Action Center of Reform Judaism in Washington, D.C. Follows this issue. Reform Jewish Voice has action alerts, or go to an organization like NARAL or Planned Parenthood and just hear directly from organizations that are working for positive change in this area. And they'll give you the most current, the action alerts will give you the most current information about what's going on, about whom to contact, to make phone calls or send emails. You can also meet with legislators in your district or in Albany. I like to say that if you can have a conversation, if you're capable of having a conversation with somebody, you are capable of advocating, because that's really what it is. It's as simple as having a conversation with somebody. Advocacy Day, Reform Jewish Voice has Advocacy Day once a year. We also run a separate one for teens. Come to an Advocacy Day and join either with Reform Jewish Voice or with another group like NARAL or Planned Parenthood. Learn what it is to advocate. It's really not a scary process at all. It's actually kind of fun, especially if you do it with other people who are like-minded. And I want to just end by saying that it really does not take a lot to bring attention to an issue. So if you ever think, well, what does it matter if I don't raise my voice? I'm going to tell you that it really does matter. And with that, I will thank you for inviting me to speak, and we'll turn it back over.
Thank you. Thank you, Rabbi. Thank you, Rachel. What an honor to hear from two such articulate experts in this area. We really appreciate it. And now we have the luxury of some time for your questions. So if you have a question for either or both of our speakers, you can use either the chat function or the Q&A function, which should be on the toolbar of your Zoom screen. And while you're doing that, we do have one question that came in while you were speaking from our WRJ Executive Director, Rabbi Marla Feldman. And she is saying, can one of you, Rabbi or Rachel, talk a little bit about the situation in other states? Because it was a wonderful description of the advocacy going on in New York State, and I'm sure everyone listening realizes that every state is different. And if Roe v. Wade should go away, we will be reverting to state law. So how would women in other areas take first steps to get involved?
I'll take a first shot at that, and that would be, I would make connections with the organizations in your state that are organizations like NARAL. I think they're national, and Planned Parenthood is also national. So they would be the ones who are most, I think, in touch with what's happening locally when it comes to reproductive rights.
Wonderful, thank you. Rachel, any comments from you?
Yeah, I'll just add quickly. I think that that's absolutely right. Going through organizations like Planned Parenthood and NARAL, and I will also say that the ACLU has affiliate organizations in several states throughout the country. And we also know that we work with a lot of independent advocacy organizations that only exist in one state. So if you're trying to get involved in one state, I encourage you to reach out to the Law Center and we can let you know if there are folks in that state. And then sort of the one specific point I'll add on that is we do know that there are about, I believe it's 18 states in the country that are poised to make abortion illegal if Roe v. Wade were overturned. They have what we call trigger laws on the books that mean that the moment that Roe is overturned, their state law would change on that issue. But, you know, we also see all sorts of ways that states like New York and California are trying to push forward some really wonderful proactive legislation, and we would love to have folks getting involved there. And we've seen actually one of the areas we've seen a lot of attempts to expand access to abortion is state laws requiring some insurance plans to cover abortion. So I would just also encourage you to reach out to those organizations or reach out to us, and we can let you know if there are efforts in a specific state you can plug into.
Wonderful, thank you. For both of you, can you tell us what would you say right now today is the biggest threat to Roe v. Wade?
That's a tough one. I think that I would say that for me and the work that I do, I think the threat is actually sort of the really unfortunately clever ways that we see folks opposed to access to abortion trying to undermine that right, and that I think that the sort of laws that they're passing now really impact the most vulnerable communities, and that's unfortunately and too often goes unseen. Like I said, for poor women, women of color, trans folks who need access to abortion, or for example, as you've heard, the administration's trying to stop unaccompanied, undocumented minors from getting abortion that are currently in federal detention. So I think it's the way that current restrictions impact people who don't have the same ability to have a voice in our state houses and in our federal government.
Yeah, and I would just add to that, if you pay attention to the language that's used, like they will, because language can shape reality, and they will, I think this was in Texas, correct me if I'm wrong, but when you talk about requiring that abortions be provided in a certain medical setting, and that was to protect the woman's health, pay attention to the way that language is used, even the whole idea that if you're against abortion, you are pro-life. That's something to pay attention to and to challenge.
Mm-hmm. Yeah, wonderful. We have a question from Julia Weinstein, who is the WRJ Vice President in this role today, and will be transitioning, as I said, in a month. And she asks a great question. What effects are we seeing already from limitations on access to abortion in certain areas of the country? I have seen articles suggesting an uptick in interest in self-terminations. Any thoughts about this?
Yeah, I think that we are seeing more self-induced abortions in some parts of the country as a result of clinic closures. We do know that looks a little bit different now than it did in 1973 because of the realization that there's medication that can be used for safe and easy access to medication abortion. And so self-induced abortion is a little different than what folks envision in a pre-Roe world. So I think we do see more of that. You know, we also know that women denied access to abortion when they wanted one. There have been these really great studies that show they're more likely to be living in poverty if they were denied abortion when compared to women who got the abortion they sought. So we know that it further entrenches economic inequality, particularly in communities that are already struggling with economic insecurity.
Mm-hmm. Mm-hmm. Yeah. Any other questions from the group? We do still have a couple more minutes to answer another question or two. Okay, well, seeing none, we did have a question that was answered in writing about the availability of this session afterwards. And this session is being recorded, and all the sessions in this series are recorded, and they'll be available afterwards to view. So please spread the word about that. Okay, so let me send it back to Allie to tell you about the next session in the series.
Absolutely. Thank you so much, Jane, and thank you so much to Rabbi Jake and Rachel. I really appreciate your both different experiences and expertise within this subject, and we really appreciate your insight. All the information from this session will be shared with all the participants following. You will receive a follow-up email tomorrow with a post-evaluation survey as well. Please fill that out and to make sure that I'm doing my job correctly and to make it better for all of you. And then please also join us for our next session, which will be in March, focusing on human trafficking. I know our WRJ women are very interested in learning more about this subject. So I'm very excited to say that we'll have two speakers. One is Edie Franklin. She is the founder of Sanctum House, which is a human trafficking survivors shelter in Detroit, Michigan. And then we also have Rebecca Chamberlain, who is a lawyer within California that helps with human trafficking advocates. So there will be no session in February due to Freed Leadership Conference. I hope we'll see most of you at the conference in Nashville in the beginning of March, but if not, I hope to see you on this next session. Thank you very much, and have a great rest of your day.
Yes, thank you all for coming, and we're so glad you joined us. Please spread the word about these sessions, because as you can see, they are enormously valuable, both for people to attend live and to watch the recordings afterwards. So thank you to everybody, and hope to see you all in March.
Thank you.